All right, so our project is on the right to privacy, contraception, and abortion. Contraception is the deliberate use of artificial methods to prevent pregnancy, and abortion is the deliberate termination of a human pregnancy.
The Constitution and its provisions are ground for direct functioning of the U.S. federalism, both the government and the states. It serves as a blueprint or grounds for how a nation or state should be run. These are the articles or clauses or amendments under the Bill of Rights and the Constitution, which both carry national and state power in order for laws to be constructed. And the judicial branch determines the laws to be unconstitutional, also known as the Supreme Court. Although privacy is not specifically stated in the Constitution or Bill of Rights, it is interpreted that the Ninth Amendment in the Bill of Rights serves as the direct right to privacy. It states that the enumeration in the Constitution of certain rights shall not be constructed to deny or disparage others retained by the people. It was implemented in the Constitution on September 5th, 1789, but voted by 9 out of 12 states on December 15, 1791. The concept of rights to privacy were developed by Samuel D. Warren and Louis Brandeis in 1890.
Okay, so Supreme Court decisions. In 1965, Griswold v. Connecticut passed a court ruling that the U.S. Constitution protects the liberty of married couples to buy and use contraceptives without any government restrictions. January 2nd, 1973, Roe v. Wade passed a court ruling to grant the right to an abortion, making them more accessible to women. In 1986, Lawrence v. Texas ruled that sanctioning of criminal punishment for someone's consensual private sexual conduct was unconstitutional. June 29th, 1992, Planned Parenthood v. Casey. The U.S. Supreme Court upheld the right to have an abortion. Pennsylvania's Governor Robert Casey enacted new abortion statutes, causing Planned Parenthood to question the constitutionality of the statutes. June 27th, 2016, Whole Women's Health v. Hellerstedt. This U.S. Supreme Court decision helped preserve abortion access for Texas women and caused laws like those of Texas to seem unconstitutional. June 29th, 2022, the U.S. Supreme Court ruled on Dobbs v. Jackson Women's Health Organization. With the ruling, the U.S. Supreme Court upheld Mississippi's ban on abortion at 15 weeks of pregnancy and overturned Roe v. Wade, meaning that there was no longer a federal constitutional right to getting an abortion in the United States.
The New Zealand Abortion Legislation Act in 2020 is an act of Parliament in New Zealand that amends the law of dismissed abortion. President Joe Biden signed an executive order on August 31st of 2022 to help ensure access to abortion. The order will help women travel out of the state to get an abortion or any emergency procedures.
Roe versus Wade was a landmark case that changed the direction of abortions all across the country in 1973. This case brought the issue of abortion to the federal government rather than just in the hands of the states, making abortion more accessible and legal in all states. Before this decision, abortions were illegal in Texas. Norma McCorvey, also known as Jane Roe, filed a class action lawsuit in which the Supreme Court found that Texas's strict abortion laws were unconstitutional, citing the 14th Amendment.
Planned Parenthood versus Casey. Planned Parenthood versus Casey in 1992, the Supreme Court affirmed what is called the central hold of Roe versus Wade, that states may not prohibit abortions before fetal visibility, the point when a fetus could survive outside the womb, which is now about 23 weeks.
In the Lawrence v. versus Texas in 1986, the Supreme Court ruled that the criminalization of sex acts between two people of the same sex. In September of 1978 in Texas, Lawrence and Garner were found engaging in sexual activity by the police after receiving a tip from Garner's former boyfriend, Eubanks. He reported that a black male was going crazy with a gun. in Lawrence's apartment. The case issued that the Constitution protected their rights and struck down on the law in Texas. In 2003, the U.S. Supreme Court overturned criminal punishment for sodomy, marking it unconstitutional. The decision in Lawrence versus Texas gave the right for adults to have non-commercial consensual sexual relationships in private.
The Griswold versus Connecticut case occurred in 1965. Connecticut law made it illegal to encourage, use, and distribute birth control contraceptives to married couples. Estelle Griswold was an employee at Planned Parenthood who was found guilty for providing contraceptives illegally in the state of Connecticut and was fined for doing so. She appealed this, and the case went to the Supreme Court. The Supreme Court ruled in Griswold's favor, citing right to privacy laws, and found that making access to contraceptives illegal was unconstitutional.
Whole Woman's Health versus Hellerstedt. On June 27, 2016, Whole Woman's Health versus Hellerstedt, the U.S. Supreme Court decision helped strike down 2 Texas abortion restrictions that were being challenged. These medically unnecessary restrictions were passed in 2013 by Texas legislators, causing doctors providing abortion services to obtain admitting privileges at hospitals no further than 30 miles from them, and any facility that offers abortion has to meet building requirements to, in other words, become a mini hospital. This had singled out women's healthcare and were restrictions that have never been seen before in any type of healthcare. By 2015, Texas clinics that offered women abortions had gone from 40 to 19. By the end of the Whole Woman's Health versus Hellerstedt case in 2016, the U.S. Supreme Court had ruled 5-3 and eliminated the Texas law that created an undue burden for women seeking an abortion and was designed to shut down almost all of Texas's abortion clinics with their restrictions.
We added this next clip to show how monumental cases as discussed can significantly impact the state and local laws as well as individuals.
Next conversation with NBC's Justice correspondent Pete Williams. And Pete, the Supreme Court has spoken, but that is not the end of the legal challenges.
No, and in fact, they've already started in the states. Planned Parenthood is challenging the trigger law now in effect in Utah, saying that even though the Supreme Court has ruled that there's no right to abortion in the U.S. Constitution, the right is nonetheless protected by Utah's state constitution because it provides greater family-related legal protections and guarantees of personal autonomy. There's a similar suit in Florida. It says the state's privacy laws protect the right to abortion. And the courts are going to have to answer some other questions. For example, can a state make it a crime to travel to another state to get abortion services, or can it ban advertising or counseling about how to get those services where they're legal? And do the banning states have to allow exceptions for rape, incest, and protecting a woman's health?
I'll add one more. Another big question is over abortion by medicine, the abortion pill, as it's called. Some states may want to target that medication.
Well, and already have. In the states that ban abortion, it is illegal to get those pills from a doctor. And some states are trying to go further and also ban receiving the pills by mail from a state where they're legal. The Biden administration says the states can't do that because those pills are approved by the federal government, and the courts will probably have to decide that, too.
Well, and it also raises the question, when you look at this decision, that it dismantles the legal underpinning of Roe versus Wade, but does that have an application to other cases, for example, gay marriage or contraception? Clarence Thomas, in his concurring opinion, said yes. Do you expect those issues to come up before the court in the future?
I don't see them coming quickly, but the reason for the question is that Friday's ruling says there is no constitutional right to abortion because it is not deeply rooted in the nation's history and tradition, and certainly same-sex marriage and access to contraceptives would flunk that test. So Justice Thomas says the court should take another look at them now, but the majority in the ruling said 4 separate times that it was only about abortion and doesn't threaten those other rights. So about all you can say is that they appear to be safe, at least for now, Savannah.
All right, Pete Williams, thank you very much.